Scotland, and the Scottish law did not require that it be made under seal, the English court held that the transaction was valid. The transaction cannot be validated on the basis of former validity. So in other words, even former validity will be governed by lex situs. So if you want to come to Nigeria to say that you want the court to give effect to the contract relating to land located abroad, okay? And the issue becomes whether the document containing the contract is valid or not. The governing connecting factor will be lex situs. That is the law of the place where the land is situated. So I want to trouble you in an exam, and I tell you land is located in Kumasi, but the Ghanaian law insists that there must be a seal before you can give effect. Whereas Nigerian law does not require that you need a seal. Okay? You have done agreement in compliance with Nigerian law, transferring Ghanaian property. But Ghanaian law requires that the form of that agreement must be different from the form you have done in Nigeria. So you ask the court to give you order of specific performance, and the other party raise the issue of whether there is any document of the contract upon which you can ask for equitable remedy. The court will determine the validity of the former validity of that document using lex situs. That is the law of the place where the land is located, and not the Nigerian law where you are allowed to sue simply because you are seeking equities or contracts, as an exception to the rule in BSA and Compare de Mozambique. The next question is the question of capacity. You know that different countries have their rules regarding who is capable of doing what. Nigerian law, for example, I think if you have not attained maybe a certain age, maybe is the age of 21, or sometimes by start to age of 18, you cannot convey land. Okay? Some countries do not give married women. So some countries will render some people incapable of transferring land. Okay? So if the law of state Y forbids or renders somebody incapable of transferring land, suppose the land the person wants to transfer is located abroad. Okay? How will that play out in a case where the issue of title to immovables is being taken outside of the place where the land is located? In other words, suppose somebody says he wants to enforce equity contract, administration of estate and what have you, in relation to foreign land, okay? And the issue of his capacity or the issue of capacity to transfer arises. What is going to govern that issue? Is it lex domicili or lex situs? Are you going to apply the law of the place of domicile of the assignor, or are you going to apply the law of the place where the land is located? Now look at the following cases. Look at some cases that Morris discussed. The first one is the case of Proctor and Frost. Proctor and Frost. Okay? The land was located in England. Okay? But a married woman domiciled in Massachusetts was the surety. Okay? So she served as surety for her husband and gave as security a mortgage on land that she owned she owned the land in New Hampshire. It's an American case. Okay? So the mortgagee brought proceedings in New Hampshire to foreclose the mortgage. But the mortgagor defended by saying that under New Hampshire statute, a married woman could not become surety for her husband. So, which is going to apply? Which is going to apply, lex situs or lex domicili? She was domiciled in Massachusetts, but the land was located in New Hampshire. Okay? By Massachusetts law, she was quite qualified to serve as a surety for her husband. But by New Hampshire law, where the land was located or is located, she lacked that capacity. So the New Hampshire court rejected this defense on the ground that the primary purpose of the statute was not to regulate the transfer of New Hampshire real estate, but to protect married women in New Hampshire from the consequences of their uh, reinforcing credit of embarrassed husbands. Okay? So, in other words, a deep thinking American court preferred, in that instance, not to apply lex situs. Because the land was located in Hampshire, New Hampshire, if they were to apply lex situs, it would have meant that that would be a good grant. That would be a good grant to invalidate the mortgage. But she actually was domiciled in Massachusetts. And so, hello? I hope I'm communicating. Hello?
Yes, sir. Yes, sir. Yes,
So,
sir.
read the case of Proctor and Frost. The English court refused to apply lex situs to the question of capacity of a married woman to mortgage or transfer her land. They refused to apply lex situs. Instead, they applied lex domicili. She was domiciled in Massachusetts, and by Massachusetts law, she was qualified to execute a guarantee for her husband. So the fact that the land was located abroad did not matter. Okay? So that was an action that was taken in New Hampshire. Okay? Where the land was located. And the New Hampshire court refused to apply New Hampshire rule, rendering incapable the wife because, according to them, the wife was domiciled elsewhere. And by the law of the place where she was domiciled, she was quite capable of transferring land or mortgaging it. Compare that with the case of Bank of Africa and Cohen. Let's look at the facts. Maurice titled this one Capacity When Land is Abroad. Because in this case, the case was going on in England, but the mortgage related to land based in South Africa. By South African law, the woman had no capacity, but by English law, she had. The English court held that the mortgage was not valid because by the law of the place where the land was located or is located, she was not qualified. Of course, Morris criticized the decision on the basis that you will see the difference between it and the Proctor and Frost decision in the first instance. And secondly, the situation in which the bank was allowed to be duped because the woman knew of South African law when she pledged her property in South Africa as security for the debt of her husband. And she knew that she was able to prevent the bank from dealing with her husband by doing that, only for the court to say that, well, since the property was located in South Africa, and by South African law, a wife was not qualified to uh, secure a loan of a husband, therefore the entire transaction was a nullity. Maurice said that a lot was wrong with the logic of the court, and that if they had followed Proctor and Frost's reasoning, which is that she being domiciled in England, it is lex domiciliis that should govern, not lexitus. Maybe justice would have been arrived at. Okay? So, on that note, we leave immovable. Let's move to movables. I told you that movables are also divided into two. We have tangible movables and intangible movables. Tangible movables are your physically transferable property. Okay? Like your bag, your car, your valuable transferable possessions, etc., etc. So there are two different scenarios with tangible movables. The first one is where the situs remains constant. You will say that there's virtually no difference between immovables and movables that remain constant. Do you agree with me? Hello? When we were discussing immovables, we highlighted the fact that lexitus is the rule and operates and makes a lot of sense because everything about the property is in one place. Why should the rule be different? even where the property is movable but has never moved. If everything, if all the, if at all material times, the particular tangible movable was in one country, why should not the law of that country be the one that will govern whether property has been validly transferred or not? So, Lexitus does not take on a complexity. It doesn't take on a complexity where the movable, where the property, though movable, has never moved. It is the same Lexitus rule. Although in theory, you will have debate as regard why use Lexitus? Why don't you use Lex Contractus? Why don't you use Lex Contractus? Why are you insisting on Lexitus? Okay? We will normally cite for you the case of Glencore International AG versus Metro Trading International, where the court highlighted. Sorry, somebody called. So as I'm saying, the court, are you hearing me?
Yes, sir.
The court in that case I cited explained why Lexitus is the proper test to apply. The court said it has the great advantage of certainty because except where goods are in transit from one country to another, goods are likely to be, the rules is likely to be easily ascertainable. Okay? The court also explained that it will meet the natural expectation that the law of the place where they are transacting and the asset is located is the one that will govern their contract. It's the one that will govern the of property. So you might have a situation where foreign law or different law will govern proper contract, but as far as property is concerned, it will always be the lexitus. Okay? And the cases also say that RUVA will also apply. In other words, that you should apply whatever rules of law the court of the state where the property is located will actually apply in determining the question of property. So that is the law as far as unchanging status is concerned. But where you have a situation where the status change, for example, you have an intangible movable, and the relationship between two people that started from Nigeria. But the intangible movable was later to be moved from Nigeria to Benin Republic or to Ghana and all of that. And the question is whether all through this period, what was the meaning of Lexitus? What was the meaning of Lexitus? Okay? Somehow I have a feeling we are not enjoying this class. And I don't like a class where people are not following. I'm hearing noise and all of that. Let us continue on Thursday. Hello? We'll continue on Thursday, and I will start from tangible movables. Okay?
Okay, sir.
All right,
Yes, sir.
sir.
Thank you, sir.
Some of you, the moment you sign that you are in class, you just left. Only 47 people are participating in this class. That's not good enough. Oh. You are deceiving yourself anyway. The few ones that are in class safe, it doesn't appear as if they are paying so much attention. Hmm? Go do them in there.